Hi, I'm Gina Johnston.
And I'm Alec.
In this video, we're going to look at enforcing judgments. The technical name for enforcing judgments in Scotland is called diligence, and Alec and I are going to give a very high-level overview of some of the most commonly used diligences we have in Scotland. The first thing to mention when we talk about enforcement methods in Scotland is really the charge for payment. A charge for payment is a prerequisite to some diligences being carried out. A charge for payment is a formal demand specifying the sum due in terms of the decree, the cost of serving the charge, and usually an amount of interest. It is served on the debtor by an officer of the court. In the sheriff court, they're called sheriff officers, and in the court of session, they're called messenger at arms. They're akin to an English bailiff, for those of you more familiar with that term. The charge for payment can often be an effective enforcement method in itself, encouraging the debtor to make payment without further action being taken, or to discuss the debt with the creditor and make proposals. The charge allows the debtor 14 days to pay the debt, and if the debtor fails to pay, then the creditor can instruct the sheriff officer or messenger at arms to carry out diligences on their behalf to recover the sums due. Failure to pay the charge within the 14-day period also constitutes apparent insolvency and can found the basis for a bankruptcy petition of an individual, what we in Scotland would call a sequestration, or for the winding up of a company. A charge for payment lasts for a period of 2 years.
Arrestments are used where money or movables belonging to the debtor are held by a third party. The arrestment is served on the third party and prohibits them from transferring the money or movable to the debtor. One of the most common forms of arrestment is a bank arrestment. This is served on the debtor's bank, freezing funds belonging to the debtor until such time as the debtor pays, subject to a statutory protected minimum balance where the debtor is an individual. If an agreement cannot be reached with the debtor for payment of the outstanding sums, then the sums caught are automatically released to the creditor after 14 weeks. If the bank account is a joint account in the names of both the debtor and their partner or a family member, for example, the whole account can still be arrested. In most cases, a charge for payment is not required to serve an arrestment. Arrestments are time sensitive and as a result are often speculative. For example, if I were to serve a bank arrestment today, it would only catch what is in the debtor's account today at the time it is served. If the debtor paid in £1 million tomorrow, that would not be caught.
This is a special form of arrestment served on an individual debtor's employer and obliges them to make a deduction from the debtor's earnings and pay this to the creditor. To carry out a wages arrestment, the creditor needs to serve a charge for payment first on the debtor, together with a debt, advice and information package. The amount of the deduction is determined by a statutory scale, depending on the income and frequency of the debtor's pay, and this is updated from time to time. Similarly to a bank arrestment, there are minimum balances that are protected by statute, and for some very low incomes, no deduction is permitted to prevent hardship on the debtor.
Under an attachment, goods belonging to a debtor are seized with a view to their ultimate sale by auction. The sheriff officer or messenger at arms will prepare an inventory and valuation of the debtor's movable property, and the attached items may subsequently be auctioned and the proceeds distributed to the creditor, after deduction of the sheriff officer's or messenger's at arms fees and the auctioneer's fees. In the majority of cases, the threat of assets being sold at auction prompts the debtor to pay, or at least to make proposals. The creditor needs to have served the charge for payment on the debtor before executing an attachment. Special rules apply to individuals. To attach non-essential goods inside a debtor's home, an exceptional attachment order must be obtained from the court. As the name implies, they really are exceptional in nature and rarely sought in practice. They may be sought where, for example, the creditor has exhausted all other diligence options available to them. There is also a long list of exempt assets which cannot be attached to prevent hardship to the individual and their family.
One of the most commonly used and effective diligences is an inhibition. It is considered as a so-called freezing diligence, preserving a debtor's assets. An inhibition prevents the debtor from dealing with their heritable property, including land, residential and commercial buildings, either by transferring title, selling the property, or by burdening it with standard securities, that is to say mortgages. The inhibition requires to be served on the debtor and is then registered in an official register called the Register of Inhibitions. An inhibition lasts for a period of 5 years and covers all of the debtor's heritable property in Scotland. The inhibition can be renewed before the expiry of the 5 years by serving it on the debtor and registering it again. Unlike a charging order in England and Wales, an inhibition is not a form of security and is not limited to specific property. If a debtor wants to sell their property or obtain further securities, they will, however, need to have the inhibition discharged first in order to do so, and that requires engaging with the creditor, who will insist on payment as a condition of discharge. It is important to bear in mind that an inhibition prevents only future voluntary acts. So if a debtor has already committed to a binding contract of sale of their heritable property, what we would term binding missives, for example, an inhibition is served, the inhibition will not prevent the sale, as the debtor is legally obliged as a matter of contract to sell. Equally, an inhibition does not prevent the sale of property by a trustee in bankruptcy, as that is not a voluntary act. A charge for payment is not required to serve an inhibition on the debtor.
A creditor may use any unpaid debt, including a debt under a foreign judgment which has been registered for execution in Scotland, as the basis of a petition for the sequestration or bankruptcy of an individual debtor, or for the liquidation or winding up of a company. As we mentioned earlier, an expired charge for payment can be used to show a debtor's insolvency, as can an unpaid statutory demand. These can be very useful diligence tools, particularly when dealing with individuals who hold directorships and are keen to maintain them, or with companies who are keen to maintain their reputation and hold on to their business. We don't have time to discuss these in detail today, but please get in touch with us or your usual Shepherd and Wedderburn contact if you would like any further information on insolvency procedures, or indeed any of the diligence options we've covered.